Good morning, everyone, and welcome to the January 4th sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan, and to my right, your left, is Justice Shin, and to my left, your right, is Justice Hodgens. We will be your panel today. We have 5 cases today, and we will take a brief recess after the third. Each side has 15 minutes, as you know, and there will be no rebuttal. We encourage you to get to the heart of your argument. You can be assured that we have read your briefs with care. With that, we'll call the first case, which is 21P0871, Commonwealth versus Edward Kavanaugh III. Is this Attorney Fox?
Good morning, Your Honor. James Fox on behalf of Mr. Kavanaugh. First, I'd like to say it's good to be back in Boston. The last few cases I've had have been by Zoom throughout my house, and the last one was at the law school up in Andover. So hopefully we're back to better stead here. Mr. Kavanaugh asked the court to consider one question today: the admissibility of the booking video from the station. This is a case that poses as a discovery violation, but it's really an evidentiary question. So the arguments, the facts kind of rode the line, but at its heart, this is a review of a motion in limine, whether the evidence offered, whether it's more prejudicial than probative. The late disclosure of its use at trial, Mr. Kavanaugh submits as a factor in whether this evidence is appropriately admitted. But just at the start, I'd like to just kind of billboard this here. It's not a discovery argument. It's a motion in limine. The video depicts Mr. Kavanaugh. This is an OUI conviction. It depicts him in a booking at the Randolph Police Station. Mr. Kavanaugh submits that the video is prejudicial and that it is cumulative. There's a significant amount of testimony from the officers about his state, about when he was removed from the car, his ability to stand and such. The video really adds nothing to the evidence, and its late disclosure of use, in fact, its disclosure of use only happened 2 days before the trial. The Commonwealth makes significant...
Counsel, can I just interrupt you for 1 second?
Certainly, Blake.
I noticed that Judge Colvin had indicated that the video, the disclosure of it, he said it's not a surprise. How do you get around that?
Its use was a surprise. Its disclosure wasn't. It is a district court appeal. It is a kind of more of a fast-moving court than the Superior Court. The video was disclosed, and that's one thing that Judge Colvin pushed back on with the defense at trial. If it wasn't disclosed, the term surprise is used a couple different ways here. This is not a late disclosure of a discovery disclosure, so there's no surprise in discovery. The surprise here is in the use of the video. The district attorney covering the motion session, the limine session 2 days prior, did not think that the video would be used at trial. Then he reached out to the ADA who would try the case, who did decide to use it. So the question here really is, was it within the trial court's discretion to admit the evidence, the video, or should the court have either precluded it, which I'd submit as an appropriate avenue, or push the trial back to another date?
So I didn't see anywhere in the record where there was a request for a continuance. Was that
That's
made?
Appendix 19. It's a one-page limiting motion. I think it's in the second paragraph, and the record here came in kind of fast. There's 2 transcripts. I filed the second transcript after I filed my brief, so I don't have any cites to it. But this is a big day for me. This is my first appeal from a restaurant. The case was tried at Lombardo's in Randolph, so the record kind of came in a little hodgepodge. It was conducted during COVID. It kind of gave everybody a little bit of a lift in putting the record together, but there was a significant struggle in trying to get the audio, get these things transcribed. So I'd ask the court if the court could check on its side. You should have 2 volumes. They came in separately. I believe the Commonwealth cited to both volumes. I only cited to the trial volume. To answer Justice Shin's question, though, it was argued, it's about a 15-page transcript, so I don't have a page cite. I believe it's probably somewhere around page 10 or 12.
Okay, so as I take it, your argument is a piling on argument, that it was cumulative and therefore prejudicial, it's too much.
Exactly.
All right, so here's my question on that. The jury wasn't required to believe the police, so why wasn't the Commonwealth permitted to put in the video evidence to show that the officer's testimony was accurate or not, depending on what the video showed?
Well, it's really the collective factors. The video does depict Mr. Kavanaugh in the jailhouse setting. The Commonwealth discusses how it's actually a booking at a police station. The video's in the record. If you look at the record, it does appear to be what a civilian would think of as a jail, meaning it's a lot of concrete, security, a booking area. So I suggest to the court that the collective factors of the video are more prejudicial than just the police testimony. It isn't all, the court does correctly point out that it is a different manner of offering the evidence. So you have the police testimony. I believe Officer Ellman testified. I don't recall whether one of the auxiliary officers testified. That's escaping me right now. But Officer Ellman's testimony was consistent with what the whole Commonwealth's narrative would be.
So what if the officers didn't testify about it at all? They just said he behaved the way he behaved on this video. Here's the video. Would that have been error in your view?
I think that the question more focused is whether or not it's cumulative. So whether, the question would be whether the video as the court pointed out, does it pile on to the evidence already in play, or is it significantly different? So, and to follow the court's question, if the video is significantly different, then the relevance argument supports the Commonwealth's position.
But if in fact it is purely cumulative, I don't see how there's any prejudice.
Well, the prejudice will be, it does depict them in a criminal detention environment. It's not relevant. It doesn't meet the bare admissibility standards that relevant.
Yeah, I guess I'm a little bit confused about what precisely your argument is. Are you saying that there's something prejudicial, unfairly prejudicial in the video itself that outweighs the probative value, or are you saying that the prejudice stems from the late revelation that they were going to use this video, which precluded the defendant from offering medical evidence?
Well, to parrot my teenagers, I'd say all the above. But
Okay.
to answer the court's question more directly, there's no relevance, meaning it does not take a material fact and make it more or less likely, meaning that the evidence of inebriation came into the police officers of Mr. Kavanaugh's balancing his conduct, his physical ability, that the issue, the definition of relevance under the rules of evidence is material fact, more or less likely. It does not make anything more likely. And so
Well, it shows his appearance and
which was before the court
behavior.
already.
Only if you believe the officers. The jury were not required to believe them, so why doesn't the Commonwealth... See, one person's corroboration
Right.
is another person's piling on, and we're talking about where the line is.
And I suggest that this is one of the situations where it is difficult to attack the officer's credibility, which sounds like a difficult argument for a defense attorney to make. But the officer's testimony tended to be relatively neutral. It was corroborated, I'm talking about Officer Ellman, it was corroborated by by what came in through the auxiliary officers. And to address what Justice Shin said, that the argument essentially is that there's no relevance here, getting beyond, because no material fact is made more or less likely. Getting beyond that, there's threads of prejudicial impact, and that he's seen in a police station, and what a civilian would think was a prison. And the Commonwealth didn't try to point out that it's not a house of correction, it's not a prison. These are things that are meaningful to attorneys, but when a civilian witness looks at this, and it'll be in the video that's available for the court's review, he is, gray concrete, fortified doors, uniformed officers, what most of us would think to be a criminal detention.
Let me just ask you this, because I've looked at the video, and it seems pretty benign. It's a routine booking. The defendant is not falling down drunk. He's conversational. He's pretty steady on his feet. I could say he's holding on to the bar, but it looks like anyone would do that.
I'm
standing
holding
there.
onto the table right here myself, so it's understandable.
So it kind of cuts both ways. I mean, in fact, it may even contradict the officer's testimony to a certain extent because, as I said, he seems to be in pretty good shape, not showing any severe indication of intoxication, wouldn't you say?
Candidly, that's how I viewed it. At trial, the defense attorney was concerned that the video should not come in. It was a primary focus. I think she has a good argument. What the court's driving into is really what different fact finders, what different jurors might see. The fact that, I'll go back to the fact that it was what I would call a prison setting, which there's a reason that we don't bring defendants in the courtroom in orange jumpsuits. We give them a suit and tie. And there are inferences that the video, I saw the video as more prejudicial because of that he's, you know, Lieutenant Greener's in front of him asking questions. I want to say Officer Elman's on the side. It was another Randolph officer, male. I don't recall the name. But there is a prejudicial impact from bringing that video in. So I guess there's a little bit of split among counsel. Trial counsel saw that his standing behavior was more problematic. When I reviewed it myself, I didn't see it as much. But maybe we're getting into jury issues.
Let me just follow up with that, because, and this kind of goes back to the question of unfair surprise. And correct me if I'm wrong, but it looks like the runtime of the video was 47 minutes, but the jury only saw 27 minutes. So there was 20 minutes cut out of that by agreement of the parties. So,
Yes, Your Honor.
one, it looks like counsel had plenty of time to address any issue of prejudicial material and did so. And two, presumably the most prejudicial portion of the video was never even seen by the jury. Would that be fair to say?
It was the day before, so this was not a significant amount of time. The video was compiled by the Commonwealth. It's unclear what was redacted, whether it was, to be candid with the court, I have no idea what was redacted from the video. It was a lot of work to get the video up to this court, and what this court saw was all that the jury saw. So, you know, anything beyond that, I couldn't speak to. As far as I think what we're stuck arguing with is, or reviewing is, you know, what actually came before the jury. That the issue of surprise, and again, the term surprise gets conflated a little bit. A discovery surprise warrants an argument to exclude the evidence. That's not what we have here. What we have here is the question of evidentiary admissibility, meaning the fact that its use was disclosed late, relatively speaking, you know, deprived the defendant of the ability to further investigate, you know, why he had any mobility issues whatsoever. So I'd suggest to the court that there is some prejudice just by what came in, if I'm answering the court's question.
Yes.
Okay. He does, would the court like me to address the second argument as well? For the second argument, Mr. Kavanaugh will rest on his brief. And if the court doesn't have any further questions, I thank the court for its time.
We're all set. Thank you very
Your Honor.
much.
Appreciate your time.
Good morning. May it please the court, Caleb Schillinger on behalf of the Commonwealth. Just on one of the points that was raised during my brother's argument, what was redacted from the video, that is set forth in filing a notice of proposed redactions that the Commonwealth submitted, and that's on pages 4 and 5 of the Commonwealth Supplemental Record Appendix. There were two large categories of evidence, or excuse me, information that was redacted. One was anything relating to the breathalyzer test, so where the booking officer, Lieutenant Greener, is explaining the defendant's rights to him, and then where she is actually administering the breathalyzer test. All of that was redacted. Another substantial category, there were a couple instances during the booking video where another police officer came in to discuss an unrelated matter with Lieutenant Greener. Those portions of the video were redacted as well. Based on my brother's argument today, I'll focus, I guess, on what is now his argument, or the issue of the admissibility of the video. And of course, the standard isn't whether it is merely cumulative or whether the probative value is outweighed by prejudice, but rather whether the probative value is substantially outweighed by the danger of needlessly presenting cumulative evidence. The video here was highly probative. It went directly to the issue of impairment, which was the key disputed issue at the trial. The defendant didn't really contest operation or being on a public way, but very much contested that he was impaired at the time, and presented a defense that his behavior, his appearance, his movements were instead explained by his alleged medical issues. And so the video went directly to his impairment and allowed the jury to hear and see for themselves his mannerisms, his movements, his speech, exactly to the point that Justice Sullivan raised, which is it corroborates what the police officers testified to based on their own observations. It would allow the jury to determine whether or not that testimony, was credible. It wasn't needless and cumulative for that reason.
It was on the booking video, only at the booking, that the defendant said he had one nip of Fireball. Is that right?
Correct. He initially
Earlier
stated,
you said beers. That was before booking, and then at booking he said one nip of Fireball.
initially said one nip, Your Honor, and then later said that it was two nips. But you are correct.
Was that at booking, but when he said that he had one nip and then later said two nips?
Correct. Both of
Okay.
those statements were during the booking video. At roadside, he had told Officer Ellman, the arresting officer, that he had had 2 beers.
So in that respect, it is not cumulative, right?
Correct. You do get additional information from the booking video that was not otherwise provided based on the officer's roadside observations. And just briefly, on the argument that this was a jailhouse setting, it was not. It was a booking room. The defendant was not in handcuffs at the time. He wasn't wearing an orange jumpsuit. And the jury already knew that the defendant had been arrested and had been taken back to the Randolph Police Station for booking. And of course, the judge instructed the jury that the complaint here and the charges are merely an accusation, and the defendant is presumed to be innocent, and instructed the jury at length on that. And of course, the jury are presumed to have followed that instruction. I don't have anything else to add to what the panel's already addressed through their questions. If the panel has any other questions, happy to take them. Otherwise, the Commonwealth will rest on its brief.
We're all set. Thank you very much.
Thank you.
The next case is 22P0069, Commonwealth versus Robert F. Jassy. Good morning, Attorney Howes.
Yes, Your Honor.
And did I pronounce your client's name correctly?
I'm sorry?
Did I pronounce your client's name correctly?
Jassy,
Jassy, okay. Would you like to take a moment and get some water?
might be a good idea. Good morning. If it may please the court, John, Hawes for Mr. Jassy. I don't have too much to add to my brief. I think I'd just like to make a few comments on the highlights. Looking at the case overall, I think that the evidence ultimately consists of the defendant's failure to perform the field sobriety tests, and then there are the statements that he was unable to do 2 of the tests, because he wasn't sober. I think as to the statements, my argument essentially is that in this particular case, they don't really have any probative value because they don't really indicate much about what they might have meant. And I think an extreme case might consist of someone who's obviously impaired by alcohol and says that, I'm not sober. It may be obvious that those statements are true. On the other hand, that there may be a case where someone says that I'm not sober, and there's really no evidence that that might be possible at all. In this case, there's something in the middle of that. And my suggestion, I think, is that the jury heard these statements and that the evidence was essentially assessed in that context, because it seems to be, I think, a fairly significant statement if the defendant, the accused, says, well, I'm not sober and I can't do these tests. In this case, I don't think that those statements add a lot to the evidence. With respect to the individual tests themselves, as to the alphabet test, he said he couldn't do it. There's some suggestion at the end, which the officer acknowledged, that he may have had some difficulty reading or he was missing words and missing letters when he was back at the station during booking. And then as to the other two tests, with the one-leg stand, he started the test and put his foot down, and then the walk and turn, he walked 6 steps and was off the line 4 times. And I think the significance of those tests are that the broader context doesn't really indicate that the performance of those tests really suggests that he was impaired to the point where he couldn't operate a motor vehicle safely. His suggestion that he couldn't do the alphabet test aligns, excuse me, with the evidence to the extent there is some that he may have had some difficulty reading, that he was missing words and skipping over letters, I think was what the officer said.
So is your argument that the jury should not basically be drawing any inference at all from his statement because he was intoxicated? I'm not quite sure I follow
No,
where
I'm
you're going.
suggesting that here the evidence was that he may have consumed anywhere from 2 to 3 beers. Some time later, he suggests that I'm not sober. I think what I'm suggesting is that the overall evidence isn't there to corroborate the truth of those statements, and therefore they're not reliable. It's essentially, it requires confirmation or corroboration according to Com v. Leonard, that these were admitted as admissions as to his culpability, and they needed corroboration. And I think what I'm suggesting is the overall context here is that he was at his friend's house. He may have had 2 to 3 beers. He was on his way home to New Hampshire, apparently didn't know his way. He pulled safely off the road. He apparently parked fairly normally, according to the officer, and that he parked fine, I think was also a quote as well. And he was using his GPS. He knew enough to get off the road and knew enough not to use the phone while he was driving. So there is that. I think that the other evidence is clearly that he provided his license, he interacted with the officers appropriately, he was not belligerent, there was no evidence that he was swaying, that he had any trouble with his balance, and I think that goes to the field sobriety test. While he didn't do them, there's no evidence anywhere else to suggest that the failure to do those amounted to evidence that he was impaired. And the officer was asked at one point by defense counsel about whether those factors made it into his police report, evidence that he had difficulty maintaining his balance, that he was unsteady on his feet, and there was none of that in evidence at the trial. So I think the argument really is that even though he states, I'm not sober, I can't do these tests, that the evidence that would corroborate the reliability of those statements really isn't there. So they should be excluded and bracketed. And when you look at the evidence of the field sobriety tests, there really isn't a lot there, and especially in
When
light
you
of-
say excluded, are you saying they shouldn't have been admitted, or are you saying they're insufficient to provide corroboration?
I think it's likely that they would have been admitted. I think I'm suggesting that the jury likely viewed the other evidence in the context of the statements, because I think when someone says, look, I'm not sober, there might not be any reason to doubt that. In this case, I think based on the evidence from the field sobriety tests, which really wasn't there, he walked the line. There's no evidence other than that said he went off the line 4 times. Doesn't say that he couldn't maintain his balance, that he raised his arms. There's nothing like that. And in fact, the balance of the incident really suggests that there weren't any problems of that kind at all. So I think that likely the jury would have heard the statements, and they did hear the statements that he was not sober. I don't think they had any real probative value in this particular case. And then setting those aside and looking at the evidence of impairment, I don't think that the field sobriety tests really offer anything substantial enough to say that he was impaired, such as that he couldn't operate a motor vehicle safely.
Now, you cited the Leonard case for the proposition that an admission to one of the elements alone is not enough. So in the Leonard case, that was the case where the defendant admitted that he was the driver, but the Supreme Judicial Court said, well, standing alone, that's not enough to convict. You need some other evidence. But that's not the case we have here, right? Because there was other evidence of intoxication, wasn't there? I mean, there was the officer's opinion that he was intoxicated. There was the odor of alcoholic beverage, bloodshot, glassy eyes, slurred speech. So the statement that he made, I couldn't do this if I were sober, referring to two of the field sobriety tests, that statement wasn't in isolation, like in the Leonard case, right?
Well, I think as to the odor of alcohol and the glassy eyes, that's not evidence of impairment. It's evidence of consumption, surely, but it's not really evidence of impairment. It doesn't have anything to say about his ability to perform. And I think as to his slurred speech, there is a question about that. There was no testimony that his speech was slurred on direct examination of the officer. The officer mentions slurred speech when defense counsel raised the issue and said, well, didn't you testify on your direct exam that the defendant's speech was slurred? And at that point, he said that the defendant slurred his speech, but it's not clear to what degree that actually happened. And
What's
I think
the significance of it coming out for the first time on cross-examination? I mean, he did agree with the statement, right?
The subsequent conversation after he agreed that agreed that the defendant had slurred his speech, he went on to provide examples of slurred speech, and he never actually got into the defendant's manner of speech per se. He merely said that excuse me, slurred speech is an indicator of impairment. Other than the agreement as to counsel's statement, he offered no real amplification on what that might have meant in this particular case. And if the court has no further questions,
Thank you very much.
thank you.
Good morning. May it please the court. My name is Anna Brayman. I'm a student practitioner from Boston University, supervised by ADA Chi Lee of Middlesex County, and I represent the Commonwealth. The evidence in this case is more than sufficient to prove that the defendant operated a motor vehicle under the influence of alcohol. The standard of review is to evaluate the evidence in the light most favorable to the Commonwealth. And under the required findings standard, the court considers the evidence at the end of all the evidence to determine whether the Commonwealth's position as to proof deteriorated. In this case, the Commonwealth must prove operation of a vehicle on a public way under the influence of intoxication. The only issue on appeal is the final element. To prove impairment, the Commonwealth can use evidence of classic indicia of impairment, such as bloodshot eyes, glassy eyes, slurred speech, unsteady balance, field sobriety tests, and opinion testimony of the officers. In this case, the defendant exhibited bloodshot and glassy eyes. The officer adopted the testimony of slurred speech on cross-examination, and the officer also testified to a strong odor of alcohol, both while he was viewing the defendant and additionally when the defendant was placed in the back of his police cruiser.
Is the Commonwealth relying on the evidence about his difficulty reading?
No, the Commonwealth is not relying on that evidence as strongly as the other factors that indicate.
Okay, I mean, is that a factor at all? I mean, there could be many reasons why somebody would have difficulty reading. Would you agree with that?
Yes, I would agree
Okay.
with that. There are several reasons why someone might have difficulty reading or reciting the alphabet. In this case, there are several other factors that indicate intoxication, and that is not the only factor relied on by the Commonwealth. During the alphabet test, as stated, he was unable to recite the full alphabet and then stated, "I couldn't do this if I was sober." On the one-leg stand test, he put his leg down almost immediately after beginning and once again said, "I couldn't do this if I was sober." On the 9-step walk and turn test, he took 6 steps before stopping on his own and was unable to stay on the line. All of these performances on the field sobriety test suggest that the defendant was operating under the influence of alcohol. Additionally, the defendant's statements that he couldn't do the tests if he was sober indicate that he was under the influence of alcohol. The defendant argues that the statements don't communicate anything about his intoxication, and we should not view them as the words that they suggest. But to entertain this argument, the court would have to view the evidence in the light least favorable to the Commonwealth rather than the light most favorable to the Commonwealth. And finally, Christopher Dreyer's testimony about the defendant consuming alcohol at his house before the incident, they don't deteriorate the Commonwealth's position as to proof. They bolster the Commonwealth's argument as they are evidence that the defendant did in fact consume alcohol before getting in his vehicle. And nothing in Dreyer's testimony was inconsistent with the Commonwealth. So because of that, it was correct for the judge to deny the required finding during trial.
What is your best case that does not involve observations of actual driving?
Yes, so the best case is Commonwealth v. Kimball. In that case, the court found that the evidence of bloodshot, glassy eyes, odor of alcohol, evidence of consumption, and failed 2 sobriety tests was sufficient to support his conviction. And in this case, we also have opinion testimony of the officers, and there were 3
That's
field
a
sobriety tests.
128, right?
Yes.
Is there a published case that you can cite that's your best case?
Commonwealth v. Jewett also includes classic indicia of impairment, such as balance, bloodshot, glassy eyes, odor of alcohol, and slurred speech. And Commonwealth v. Shabo also includes field sobriety tests. If there are no further questions from the panel, the Commonwealth rests on its brief and asks that the court affirm the conviction.
I have one question for you. It's more of an academic question. You mentioned it a couple times, and I was intrigued by it. The standard for sufficiency of evidence includes the Commonwealth's proof cannot deteriorate. Deteriorate was the word. If you have a witness, such as here, this Christopher Dreyer, and he testifies that the defendant had 2 beers, presumably indicating that he's not intoxicated, at what point can the Commonwealth's evidence deteriorate when the defendant puts on a case? In other words, if we have a standard that says we have to view the evidence in a light most favorable to the Commonwealth on the one hand, but there's always a chance the Commonwealth's case could deteriorate. If you have a defense case that's at odds with the Commonwealth's case, are we no longer looking at it in a light most favorable to the Commonwealth at that point? In other words, if this witness testifies the defendant was right as rain, does that deteriorate the Commonwealth's case? At what point does that happen, if you know the answer? So like I said, it's an academic question. I'm kind of putting you on the spot.
So deterioration occurs when the Commonwealth's evidence is shown to be incredible or conclusively incorrect.
Okay.
And that is from Commonwealth v. Ross. And deterioration does not occur merely because the defendant contradicted the Commonwealth's evidence. So there needs to be some sort of conclusively incorrect information from the Commonwealth's evidence brought up through defendant's evidence.
Okay, thank you.
There are no
I think
further
that
questions.
concludes our questions. Thank you very much. Well done. Right. So the next case is 22P0104, Commonwealth versus William A. Rogers III.
Good morning. May it please the court, Keith Kaminsky on behalf of William Arthur Rogers III. I wanted to start off by alerting the court to the fact that the sufficiency argument is limited to the fact that all of the factors need to occur at the same time. and the important issue here is impairment from alcohol. Mr. Rogers was found asleep behind the wheel of his car twice. It was 9 p.m. at night. His cigarette had burned all the way down to the filter. These facts are not consistent with someone impaired from alcohol. He was able to balance for 30 seconds.
If you could, just for a moment, would you pull that microphone slightly closer to you? You're soft-spoken, and I want to make sure that we get everything that you're saying.
My apologies, Your Honor.
None necessary.
The main issue that became apparent here at sidebar was the Commonwealth argued that the odor of alcohol wasn't present simply because the officer was wearing a mask. The officer had time to do field sobriety testing, arrest Mr. Rogers, take him through booking, have him in the cruiser. At some point, he would have been able to smell the odor of alcohol on him if he had been impaired by alcohol. And I would point the court to the Gearhart case discussing the reasons why other substances result in inconsistent results of field sobriety testing on that issue. Turning to the hearsay argument, Mr. Morse testified that he had no conversations with Mr. Rogers. He then went on to say that his fiancée, Ms. Perota, went up and spoke with Mr. Rogers while he called the police. The issue with this that the defendant objected to is that at that time, Mr. Morris had already decided that the police were needed, that there was no medical emergency, and he was investigating something that required the police. And that's why when he got back in his car and spoke with Ms. Perota, he learned that Mr. Rogers was allegedly slurring his speech. This
Well,
evidence
the
was-
way that the testimony came in, he was asked, "Did you make any further observations when he awoke?" And the answer was not really much. He was kind of slurring his words. So the way it came in, that's not hearsay, right? I mean, so I guess I don't understand the objection to it being hearsay as opposed to he didn't have personal knowledge that he was slurring his words.
So the issue here is there was a motion to eliminate filed on this that was never argued, but there was another motion filed for statements that Mr. Rogers was under the impairment of drugs, and that was heard and allowed. And these statements that Mr. Rogers' speech was slurred were part of that statement.
I'm sorry?
The slurred speech was part of the statement that was suppressed.
Right, but
So
the actual testimony, he didn't say, "My fiance told me that his speech was slurred." He said, "I observed his speech to be slurred."
We needed one more step to establish the foundation, and that was him staying to hear him speak, and we didn't get that.
Okay, but that's a different issue than hearsay. And so then that goes to my next question, which is if defense counsel on cross-examination was able to elicit from the witness that he actually wasn't able to hear anything, where's the prejudice?
The prejudice is here because Mr. Morse would have been more credible and impactful to the jury because he had no reason to lie. He was just someone at the drive-thru at McDonald's. I mean, he had no
Well-
reason to interact with Mr. Rogers.
I understood your argument to be a combination of he didn't have firsthand knowledge of the statement and he was repeating what his girlfriend told him
Correct.
when he said, okay, which is kind of a hybrid of hearsay and foundation. But even setting that aside, on cross-examination, he said, well, he was mumbling. So I'm having difficulty grasping where the substantial distinction is between slurred speech and mumbling. Both mumbling on its own would suggest that there was some impairment, would it not?
The issue here, I'm making a very fine distinction that he was under the impairment of something besides alcohol. And Mr. Morse testified that he was so far away he could see them talking. He couldn't hear them.
Well,
And that's the issue, because he doesn't have the basis to say that the speech was slurred, because he wasn't there to hear it.
are you saying that the case was tried on a theory of impairment based on substances other than alcohol?
I'm saying the evidence presented and the evidence that was suppressed, that's where the issue is.
Well, if you could
You
just
made a
be a little
statement.
bit clearer, are you saying that the evidence of drug impairment was suppressed?
Yes.
Then how can you argue on appeal that the evidence is insufficient because the evidence really showed drug impairment? And in order to make that argument on appeal, you would have to have some evidence of that in the record, and you're saying it was successfully suppressed. There's a limit to how much you can change horses on appeal.
The argument I'm making is he was either too fatigued to be driving the car, or the evidence presented was consistent with use of another substance. I mean, he fell asleep in the car twice. That was the evidence presented. No one.
That's
no
for
one's
the jury,
contesting
though,
that.
right? Whether he
Right.
was sleepy or impaired by alcohol was for the jury.
Correct.
So I'm not sure how we get, is this part of your hearsay argument or part of your sufficiency argument?
We've returned to the sufficiency argument,
All
which
right.
is very limited. He admitted to alcohol. He was asleep in his car.
I'm still,
And-
if I could ask you a question, I'm still a little hung up on the issue of the mumbling, because in the transcript, defense counsel addressed the very issue that you're raising now, and said and asked, this is on page 78, and you testified that his voice was slurred, but could you actually hear his voice? And his answer, I guess I probably didn't really exactly hear his voice. Question, could you sort of hear mumbling? Answer, yes. So he did hear the voice of the defendant. Even if he didn't speak with him and he's about 10 feet away, he heard his voice. So would you agree with that?
The issue with Mr. Morse's testimony is, unless he's directed, he can't tell the difference between what he heard and what Ms. Perota heard. And defense counsel takes the time to address that, and the Commonwealth didn't. And that's the main issue I'm raising there.
The fact that it was addressed by defense counsel makes a difference? Is that what you're saying?
It was apparent from his statement to the police, which is not part of the record, but
If it's not part of the record,
It's not part of the
we
record.
aren't, it's not part of the record.
the essential part of my argument is he didn't go and speak with Rogers. Ms. Perota did, and then he asked her about it after he had called police. So his determination if he was mumbling or incomprehensible, that's the issue. There's no way to confront that because we're not really dealing with what he heard. We're dealing with what Ms. Perota heard.
Except that he says he heard mumbling.
Well, if he's only heard mumbling, how does he know that it's slurred?
Well, but does mumbling get you to evidence of intoxication? That's the issue. Could the jury infer, together with all of the other evidence, that the fact that he's mumbling means that he's intoxicated?
I don't think mumbling adds to the analysis in the same way that slurred speech would, and that's part of the issue I'm raising.
And defense counsel brought that out on cross-examination.
Right. Turning now to the error in closing, the Commonwealth opened their closing with the statement that both witnesses had testified to the ultimate issue. That was error, that was not admissible, and it may have had an impact on the jury because it was the first thing that they heard from the Commonwealth. This was a short case. You know, the primacy of that statement would have stuck in the jury's mind, and I understand that the jury's generally assumed to follow the instructions and not consider that as evidence. But with a short one-day trial like this, it may have had an impact on the jury's decision. there's no further questions, I would rest on my brief.
Thank you very much.
Thank you.
Good morning, Justices. May it please the Court. I'm Rob Kidd from the Bristol County DA's office. I represent the Commonwealth in this matter. Turning to issue number one, the sufficiency, I would suggest there was sufficient evidence to show that the defendant was under the influence of alcohol. That evidence included slurred speech, glassy eyes, and unsteadiness. Those three things are actually listed in one of the cases that I cited in the brief. I believe it was, excuse me, Your Honor. Well, I'll turn back to that, but it is recognized in one of the SJC cases that I cited. The jury didn't have to credit the defendant's self-serving statement that he just had one beer. And the defendant's brief seems to be largely premised on the fact that that was the only evidence of that he was impaired from alcohol. But like I said, those symptoms that I just listed to you are consistent with alcohol intoxication. There, on the other hand, was zero evidence that the defendant was operating under the influence of drugs. There were no pills found or no drug paraphernalia or marijuana or anything like that. The only thing the jury had to consider before it, and the only thing that the police had to consider when they investigated, was whether this defendant was under the influence of alcohol based on the evidence. Just because the defendant showed some, or so he claims, showed some symptoms that were not consistent with alcohol consumption does not mean the jury was not entitled to find that beyond a reasonable doubt that he consumed alcohol and that was the result of his intoxication. As I cited in the brief, there's the cases that talk about inferences drawn from circumstantial evidence. Those inferences need not be inescapable. They only need to be reasonable under the circumstances. There's a couple of cases along those lines. So there was reasonable evidence that the jury decided, the jury considered in deciding that this defendant was under the influence of alcohol. Turning to issue number two, here we have an objection during the course of the trial. Mr. Morse gets up there, gets on the stand, and he says, I heard the defendant was slurring his words. There's an objection. The judge overrules the objection. The judge cannot be faulted for overruling the objection because there was no grounds stated for the objection. So as far as the judge knew, Morse was testifying on his personal knowledge. Defense counsel did not request a sidebar. They just continued with the trial. Later on, it's brought out on cross-examination, as we heard, that this was not, that Morse did not hear exactly what this defendant was saying, but he could say under cross-examination from defense counsel that he heard mumbling. Under the circumstances, as I suggest in the brief, the defendant certainly did not preserve his rights on appeal because he didn't state the grounds of his objection, and largely any prejudice that resulted from any inadmissible hearsay was blunted by cross-examination, in which it was brought out that he may have been wrong. Morse may have been mistaken. Morse admitted that he was mistaken. That certainly affected his credibility, and the jury could have considered that. Also, under the entire circumstances of the case, I don't think the slurring of the words is not important in the sense that the officer testified that he observed the defendant twice with heavily slurred speech, once at the side of the car and once during the field sobriety test. So that statement of Morse was cumulative of other firsthand observations of the defendant's speech.
Let me just interrupt you for 1 second. So you would agree that if you hear somebody mumbling, that's not hearsay, right?
No. No.
But now in your brief on page 17, you said, under these circumstances, the record is far from clear as to whether the jury was in fact exposed to inadmissible hearsay. Why is it not clear? If hearing mumbling is not hearsay, what suggests there was hearsay?
Well, mumbling, I think that what I was trying to say, maybe should have phrased it better, it's far from clear on the record that Morse's statement that the speech was slurred was based on his girlfriend's observations. That would be that's the manner in which I'm talking that there was hearsay. Because Morse got up there and said the defendant was slurring his words, so the judge thought that Morse saw it directly until it was cleared up on cross-examination.
Okay.
But on a further point, I would say that mumbling in and of itself is not hearsay. It's really, that is not a statement. Mumbling is mumbling, so I would suggest it's not a statement under the hearsay rule unless you explicate what the mumbling was. He mumbled blah 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 blah. Mumbling is just a characterization of somebody's speech that would not be a statement under the hearsay rule. Turning to number 3, which is the last issue, that would be the prosecutor's statement in the beginning of her closing argument. She did make a misstatement that at the beginning of she said, at the beginning of the case, I told you that a witness or witnesses would testify that the defendant was operating under the influence of alcohol. It's correct that no witness did actually testify to that. In fact, that entire phrase, as it stands, has been held to be inadmissible because it touches on the jury's consideration of the evidence, whether the defendant was, guilty or not guilty. As we know, witnesses can opine that a person is intoxicated, a lay opinion. Witnesses can opine that a certain street was a public way, or was consistent with a public way, but we can't put all the elements together in a sentence. It was unfortunate that the prosecutor in district court chose those words to begin her opening statement, but she followed up with just an explication of what each witness said and why that witness's testimony supported an inference that the defendant operated under the influence of alcohol. As I said in my brief, that error was not strong, that was not significant in the light of the evidence. This fellow was passed out basically behind the wheel of a car at a drive-through with a burnt cigarette coming down to his, to his fingers. He has to be, police officers repeatedly knocking on the window to wake him up. He doesn't know where he is. He's confused. He says, "I'm here." When asked, "Where are you?" he says, "I'm here." So all of those things, I suggest to you, make it a strong case for the government. Morse's testimony was consistent as well. His girlfriend couldn't rouse the defendant. And after the police officer arrived, the defendant, lo and behold, he's got his hamburger, and the hamburger from McDonald's is sitting in his lap. So he was so impaired, that obviously that he forgot, he passed out while the hamburger was sitting there. So significant signs of impairment. The alcohol is there. So I would suggest, in light of the strength of the government's case, that there was any error was not significant enough to warrant a reversal.
I just have a question on kind of a minor point, but the statement the prosecutor said, and this is almost virtually her opening line in her summation, "You would hear from 2 witnesses who will tell you who testified that the defendant was operating under the influence of alcohol on that evening." Now, you said that was a misstatement, but, I mean, isn't she really just summarizing what the evidence showed? In other words, if there wasn't evidence that the defendant was operating under the influence of alcohol on that evening, the Commonwealth wouldn't have had a case, right?
Yes, Your Honor, I agree, but it comes down to a very specific choice of words. Had the and I'm arguing the other side here, but had the prosecutor just said, I told you in the beginning of this case, the evidence would show that this defendant was operating under the influence of an intoxicating liquor on a public way, and I have shown you that, that would be fine. But to say that 2 witnesses, to say it in the manner that 2 witnesses told you that he was operating under the influence of alcohol, that was the sort of, that's arguably where the line was crossed. I think it was a pretty minor error. I know what she was trying to do. She was trying to just tell the jury that, the evidence was consistent with the defendant operating under the influence of alcohol. And I don't think the jury believed that any witnesses got up there and said the defendant was guilty, in essence, which is what the rule prohibits. So if that answers your question, I don't know if yeah.
Were the jury instructed to take their recollection of the evidence?
Yes.
Okay. All set? All right. Anything further?
No.
All right.
Thank you, Your Honor. I'll rest on the brief.
Thank you very much. We will be taking a 10 to 15-minute recess, and we'll return to hear the last two cases. Thank you, everyone, for your patience while we attended to other court business. And we will now hear our fourth case of the day, which is James Appleyard and another versus Dana Rogers and others, number 22P0566. Is it Attorney McBride?
Yes, Your Honor. Good morning. Good morning, panel, and may it please the court. My name is David McBride, and I represent the appellants Dana Rogers and Pre-Owned Auto Sales. This is a civil action which arises from the interpretation of a promissory note. My clients have appealed the assessment of damages in this matter, and my client's appeal raises three legal issues. The first issue is whether the Superior Court improperly considered parole evidence to alter a clear and unambiguous contract, the promissory note. The second issue is whether the plaintiffs, now appellees, violated the Massachusetts usury statute by charging 24% default interest. And the third issue is whether the Superior Court improperly allowed the plaintiff's motion for relief from judgment in order to increase the attorney's fees in this matter without a showing of excusable neglect. On the first issue, the issue comes down to whether or not the promissory note on its face is clear and whether it is unambiguous. We respectfully suggest that it is, and that this panel has the same de novo right to look at that document and to find it to be clear and unambiguous. In relevant part, the promissory note, which is on page 20 of the appendix, states that the borrowers, my clients, would owe $200,000, quote, or so much thereof as may be advanced, with interest payable in arrears on the unpaid principal balance at the rate of 12% per annum. We believe that that language is clear and unambiguous. Most importantly, the language that says that the interest would accrue and be payable on the unpaid principal balance. The court at the Superior Court level found that the interest was payable based on the amount available to the borrower rather than the amount actually advanced and drawn down. And therein, we believe, lies the error of law. This issue was preserved at the trial court, and the appendix at page 349 and 350 shows specifically a discussion with Judge Lang at the Superior Court wherein we identified the parole evidence rule as being relevant, as being appropriate, and as excluding any evidence other than the note itself. The difference here is a profound difference of approximately $78,000 versus $3,843 because, as the record reflects, the calculation skews once the party's interpretation of how the interest is calculated diverges. And once that happens and one party is calculating interest based on the maximum value that was ever borrowed and the other is calculating interest based on the amount, the descending balance, if you will, the error becomes rather significant, and therein lies the basis for this appeal.
If I may, I'd just like to make sure that I correctly understand the mechanics of this loan, which is it started out at $200,000 and was placed in an account in the lender's name?
In the lender's name, that is correct,
All
the
right.
Appleyards, yes, Your Honor.
And then funds were drawn on that as cars were sold and the security was released.
That is correct, Your Honor.
So, in your view, would the lender have had the ability to simply take that money out at any time, or would that have been a violation of your agreement? In other words, was that money, even though it was an account in its name, set aside for your client's exclusive use?
Your Honor, it was not. There's nothing in the note or in the practice of the parties that would indicate that the Appleyards could not have taken that account and closed it. The promissory note indicates that they're lending money to my clients in an amount to be advanced up to $200,000. They eventually borrowed more than that.
But they couldn't have taken that money and spent it all and not had $200,000 to give to your client, right? They still had an obligation to have $200,000 available to your client.
Your Honor, they had an obligation that my client could borrow up to that. They didn't have an obligation to segregate it into a particular account.
Fine.
They could have had many other accounts from which monies could have been drawn. And, Your Honor, you're correctly pointing out that that money at TD Bank was in the Appleyard's name, and the protocol was for my client to gain access, the Appleyards would have to bless every single withdrawal or any sort of transfer to my client's account.
Was this a loan or a line of credit?
You know, it was a line of credit, I guess, if in the generic term of a line of credit, because the amount varied and fluctuated. But just like any reasonable line of credit, the interest would accrue on the amount that the borrower has drawn down, not on the face value.
Where is the authority for that? What's your best case for the proposition that a loan arrangement of this nature means, with this wording, means that as a matter of law, that interest runs only on the drawdown and not on the amount set aside?
No, my basis is not a case law. It is the factual reading of the clear and unambiguous language, which says...
But that's a question of law, so it would be helpful to your cause if there was a case that said what you said, because the facts in this case are that they were charged interest on the whole $200,000 and then the whole $300,000+.
Right. Your Honor, I could not find a case that's directly on all fours with those facts. However, I would respectfully suggest that any reasonable reading of the promissory note is only susceptible to one interpretation. It says not interest on the available amount, not interest on the maximum amount that we've set aside in this account, interest on the unpaid principal balance. And I think that's a term that any reasonable mind would look at and say, yes, that's the balance that you've actually drawn down. The previous clause in the first paragraph says they'll pay back $200,000 or so much thereof as may be advanced. And then it goes on to say, with interest payable on the unpaid principal balance. I think those two clauses accentuate each other, and they have to be read together. And I don't, if the parties wanted this to be an arrangement, because it is a commercial transaction, where they said, look, you're going to pay interest on the maximum amount you could ever borrow, regardless of whether you borrow it or not, they should have written that in the note. They didn't. And I think that's where the parole evidence rule prohibits other evidence from coming in and altering the clear language of the note.
What? Go ahead.
I'm sorry. Isn't this entire appeal a bit of an end run around Judge Lang's order? Because back on June 3rd, 2021, he denied a motion to vacate the default judgment. Now, at that time, counsel, in a memorandum on page 72 of the record, counsel wrote, at this writing, Rogers can represent to the court under oath that he sincerely believes that not all of the cash payments that he and his former partner made to the Appleyards have been appropriately applied to these balances due. While Rogers and Pre-Owned admit there is some amount of money that is likely due to the plaintiffs, the specific amount is sincerely in dispute, and Rogers and Pre-Owned need discovery to be able to properly determine this amount. So Judge Lang allowed this to go forward, to deny the motion to vacate, but allowed it to go forward to provide that discovery so that you could hire your CPA and make sure that the amounts were properly applied and so forth. But now you're here and you're effectively disclaiming liability. Essentially, you're saying, well, we only owe a couple $1,000s when the judgment's for $93,000. I mean, so it's a long way of saying it. Aren't you really kind of going around what the judge had already decided?
Respectfully, no, Your Honor. The judge allowed that we could have an assessment of damages with some minimal discovery, to wit, we could verify the amounts that were actually paid, and we did do that. And in fact, the record reflects that both sides fundamentally, with very minor de minimis exceptions, agreed on all the payments and when they were made. But the fundamental difference, and it's a relevant issue, fundamental issue for the assessment of damages, is not just what was paid, but what was due. And so that's where our argument became with the judge, that the amount due, we don't dispute the amounts that were paid. Both sides agree on those. We dispute the amount due, and when one side, as I've said earlier, is anticipating, or calculating rather, the amount based on the face value as it accelerated, as it became higher, rather than the descending unpaid principal balance, that's where it was apart from each other. And yes, it turned out that it was a rather profound difference. It was, 93,000 versus a few thousand. But, Your Honor, that's not an end run. The issue with the judge was, when I got involved in the case and when the issue of the default judgment was addressed, the court, we didn't appeal that. The court found, hey, you've had plenty of time to file an answer. You didn't. I'm going to assess damages. I'll let you argue what your damages are. And that's all we did. We were coming right up the field, not an end around at all, saying, here's what our damages are. They're wrong, the plaintiffs, because they're using the wrong number along the way. And when we calculated that with our CPA, that's where we get the difference in the numbers. But I think that's an appropriate acceptance of the judge's offer to address the issue of assessment of damages. It's the very reason I believe that the judge allowed us that, saying that, okay, we're not going to have you redo this and have a trial in front of a jury. I find that there is money owed, but you two can figure out what the monies actually are. And when we did that, and the only time we were able to do that in a meaningful way was when we had all of the records and we had our accountant review them. And so I think, going back to that, once you start with the promissory note, which again we believe is unyielding in its simplicity, and you make the calculations, I think it's inescapable that this is the correct interpretation and the correct calculation. So that addresses our first issue. Your Honor, the second issue addresses the Massachusetts usury laws, or law, Chapter 271, Section 49, and specifically Section 49D. If the court finds that our first argument is compelling and that the court calculates the interest as we believe it should be calculated based on the clear language, then this argument is unnecessary. It becomes superfluous, because the interpretation would get to the issue of exactly what the amount is, which is $3,843. But if the court doesn't find that, if the court finds that the judge was correct in hearing parole evidence, we ask that the court not allow the interest to be calculated at 24%, as it was beginning in February of 2019, because that violates the usury statute. And specifically, the issue here, which was addressed in the judge's...
If I may, the argument is made, and I saw the judge's remarks on the record, that this was raised too late, that if you wanted to challenge the 24%, if your client wished to, the client was required to have raised that at a time when the opposing party could have put in evidence of notice to the Attorney General. How do you address that?
Well, Your Honor, firstly, it was addressed before the judge rendered his decision. It was addressed at the...
It was addressed at argument, but after the evidence had closed.
Yes, Your Honor.
So do you agree that the issue was not raised before the evidence closed?
Yes, but here's the reason that it wasn't, Your Honor, that for all we knew, they were going to present evidence that they had registered with the Attorney General every 2 years during the note.
Well...
And they didn't.
But the judge's decision, and we review it, I believe, for an abuse of discretion, correct?
On this part of the issue, yes, Your Honor.
All right. His take, if you will, was that this is the kind of thing that has to be flagged pre-trial.
Yes, that's what he said, Your Honor. And our argument is, first of all, we didn't have a trial. We had an assessment of damages hearing, and I think it's fair game to bring up a legal argument that's only appropriate once the other side has presented its assessment of damages. And when they did, without any note to compliance with this statute, we raised it. And I think that, respectfully, I think the judge is putting the burden on the wrong party. I think the plaintiff has the burden of proof in this civil case, and part of that burden of proof is to establish that they have complied with the statute. The
Well,
statute.
why isn't it more in the nature of an affirmative defense?
Well, because, Your Honor, the statute says that the usury law, you can't do this. You can't charge this interest unless you have specifically complied with this statute.
Right, and but that doesn't go to burden the party's burdens in a court proceeding, right? It outlines the steps that you need to take in order to do this, which I believe they said that they did that, right? That they gave notice to the Attorney General.
Well, there's no evidence, Your Honor, that they did. And I think to me, it's equivalent to an eviction where they don't give a notice to quit.
Is there a case that addresses whether this has to be pleaded in a complaint or raised as an affirmative defense?
There's no case that I located that says that specifically, Your Honor, but I think, respectfully, I think appropriate reading of the statute is that the plaintiffs have the burden to show such compliance before they can charge the interest beyond 20%. I think to put the burden on us, on the defendant, not knowing what the plaintiff's going to prove at the assessment of damages would not be appropriate. And I think it's a condition precedent to charging 24% that you register with the Attorney General every 2 years, and this is from 2013 to 2020, and we have no evidence that they did that. I think that's their burden to address it.
All right, your red light has been blinking. Thank you for your answer,
Your
and
Honor.
thank you for your
panel.
argument.
Good morning. May it please the court, my name is Robert Nislik on behalf of the appellees James Appleyard and Maureen Appleyard. This is a case where there is no abuse of discretion. Nearly all of the issues that are raised on appeal have been waived at the trial court, in part because the defendant defaulted even after they defaulted and had not filed an answer and moved to vacate their default. Multiple hearings took place and an assessment of damages at which there was a full opportunity to present evidence occurred. And the case, despite the fact that a default judgment entered against the defendants, was well litigated, where the defendants had every opportunity to present pretty much any argument they wanted to make, so long as they had done so timely.
Well, I'm looking at the appendix, page 153, and it's a little hard for me to tell exactly what hearing that is. Let me just scroll back. This is October 5th, all right? And you're and this is done by Zoom, and at that point, the issue of whether or not this is clear or unambiguous as a matter of law was raised, was it not? I'm looking at the bottom of the page. I'm sorry, Your Honor, you were breaking up, but I respectfully believe the language is unambiguous, and I would tell you that to the extent that you were considering payment history, my client's testimony would be, et cetera.
Well, that was an event, it was scheduled as an evidentiary damages assessment hearing, at a damages assessment hearing.
Right.
At which time the court provided the parties an opportunity to make arguments on whether the interest provision, in fact, was ambiguous or not. As it turned out, based upon the parties presenting evidence, the judge interpreted the note correctly.
But I'm just talking to you about the waiver issue now. You said it was waived and wasn't raised, but I see it having been raised at that October hearing, so I'm struggling with your waiver argument.
So my argument is based primarily on the failure of the appellants to object to the admission of any testimony.
Well,
their argument is based primarily
that's different.
On parole evidence.
They're not arguing parole evidence in front of us now in terms of the evidence itself. They're saying, look, the judge admitted it. We didn't agree with it. We argued to him that it was clear unambiguous, and we're arguing that to you now. They're not precluded from doing that once they've argued to the judge that the language is clear and unambiguous, are they?
I think in part, it ultimately becomes a question of whether the judge's interpretation of the note and the interest provision was correct as a matter of
Okay,
law.
let's turn to that then.
Oh, bless you. So the judge did interpret the note correctly and the manner in which interest was calculated on the note. It was clear, based upon the evidence and the note itself, that the defendants had the full use of the principal balance up to $356,580. It was clear, based upon a course of conduct by the parties, that essentially since the inception of the note, the appellants had been paying 1% of the principal per year, and that went on for many years.
We certainly understand that point as to the evidence, but the issue that's before us on appeal is whether or not we consider that evidence or whether the document is so clear as a matter of law.
Well,
So it would be helpful if you could show us, under the terms of the document, why you're right.
okay, so I think one point, to answer that question, one point that is worth commenting on is that there was a course of conduct here. There was a promissory note which was modified subsequently on 2 separate occasions, and the note itself was that the defendants agreed to pay interest payable in arrears on the unpaid principal balance at the rate of 12% per annum. And they had been doing that.
Yes, but you're going back to the facts again. I'm asking you to look at the face of the note and explain to us why the note is unambiguous or ambiguous as a matter of law.
We don't dispute the judge's finding that the note was ambiguous as a matter of law. I think that the judge was correct in finding that the interest provision was subject to multiple reasonable interpretations. The judge ultimately rejected the appellant's view that interest was or should be payable only upon the amount that they had taken out of the account at any one particular point in time.
Is this a loan or a line of credit?
It suggests, I mean, it's a contract by which one party lent money to another with the expectation that principal and interest would be paid back.
So could your client have emptied out that account and called the opposing parties up one day and said, we're done, we're not offering you $200,000 anymore, or $350,000 or whatever?
I mean, they didn't do that.
No, but could they have, under the terms of the note? Could they have just terminated the whole relationship and taken their money back?
It's hard to say. I mean, at one point in time, my clients, the lenders, stated that they wanted to wrap up the lending relationship, and that was done in good faith. And at that point, the appellants apparently decided not to continue to pay interest on the note, and somehow that led to the dispute.
So
that's
at that
before the
point,
court
when
today.
your client said they wanted to terminate the relationship, could they have taken that money out of the account?
They never did.
But could they have?
If they had asked me, I would have told them that they shouldn't.
Why not?
Because it was money that was loaned to the borrowers. I mean, whether it was in the...
So the judge found that after it was terminated in the end of 2018, During the course of the next year, the next 10 months or so, the defendants replenished the account to almost the full amount of the loan principal. But you're saying that they were still liable for interest on the whole $200,000?
Well, at that point, it was
Oh, yeah, right. But
$356,580.
even though they had replenished the amount to almost the amount of the principal, they're
Yes,
still
yes.
liable for the entire, but because your clients couldn't take that money out?
Well, my clients are in the business of lending, and the lending is done with the expectation that the borrower pays interest on the loan.
But usually when a loan is made, it goes into the bank account of the borrower. And here, the money stayed in the bank account of the lender, under the lender's name. The borrower, and they're charging interest on money that the borrower never borrowed.
The judge ultimately found that there was a that there was a common and mutual understanding that interest was to be paid on the total amount of funds available
But that's
to the
based,
defendants.
that's based on the evidence, and what I am still grappling with is the language of the promissory note, given the nature of the transaction. Can you point us to what the language is of the promissory note that supports your conclusion that the borrower was to pay interest on the full amount, whether they actually borrowed the money or not?
Pre-owned Rogers and Adams promised to pay $200,000 to the Appleyards, quote, or so much thereof as may be advanced, with interest payable in arrears on the unpaid principal balance at the rate of 12% per annum.
Are you relying then on the "or" in that sentence?
On the, well, it's the amount that is advanced. So if there's $356,580 advanced in this account, that's what is ultimately available to.
What does unpaid mean? In unpaid principal balance, what does unpaid mean?
Unpaid,
If it said available, I think you'd have a very strong argument that it means on the entire amount, but it says unpaid, so what does that mean?
I mean, I think what it ultimately means is that they have to pay interest on the full amount that was advanced in the bank account. And you know, I think that, you know, reading the note, I can see why Judge Lang found that the provision was ambiguous. I think if you read it the way the appellants would like you to read it, they're advocating a position where they've admitted and conceded to the court that there's no case that interest should be payable only on the drawn down amount. Here, there was money that the Appleyards essentially segregated from their own funds. They weren't commingled with their own funds, despite the fact that, you know, the TD bank account may have been in their name. And there was a clear course of conduct between the parties for years. Ultimately, the appellants in the case stopped paying interest in contradiction to the clear course of conduct that had existed for years on this note. And it was reasonable for the Appleyards to file suit to collect the unpaid interest. And after a default, after multiple.
So after 2018, what happened to the money sitting there in the account? Where did it go?
I believe, I mean, I didn't represent my clients at the Superior Court. My understanding is that it is currently sitting in the IOLTA account. No, I'm not sure. I can't, I know that, I actually can't answer that question. I apologize, I don't know.
Because the complaint doesn't ask for that amount back. The complaint asks for the interest, right? So that,
Right.
the principal amount presumably was available to your clients, right?
I don't believe my clients treated it as if it was available to them. I think if there were any evidence that they had withdrawn funds from that account.
Complaint says the amount due is $57,355, right? That's interest, right?
It was interest that was based upon the default interest rate, and the client and the appellants conceded that they had not paid the entirety
So
of
they're
the
not
principal
asking
back.
for any amount of the principal back, because presumably they already got it back, right?
The case was primarily brought to recover unpaid interest, due and owing under the promissory note. I know that my time is elapsing.
I'd like to ask you a quick question about the attorney's fees. And I've been once through the transcripts, and I'm not sure if I saw anything in the transcripts about when the attorney's fees issue would be reached. Was there any discussion with the judge about how and when an updated attorney's fees affidavit would be provided?
It was provided in a Rule 60 motion.
I understand that. My question was there any discussion with the judge during any of the various hearings about when attorney's fees would be decided?
No, except that an affidavit was provided in connection with the assessment of damages hearing. And
Was that provided at the assessment of damages hearing or in connection with the Rule 60B motion? Because I noted that that was dated February 4th.
I think the Rule 60B motion brought to the court's attention that it had used an outdated affidavit.
I understand that because that was an earlier affidavit. I'm asking, when was the updated affidavit filed?
The updated affidavit.
Before or after the judge issued his ruling?
It was after the original decision entered. Both parties actually filed motions for relief from judgment.
Yes, okay.
And then,
So it isn't as if, I saw that your motion said that he relied on an old affidavit. That would suggest that he had a new affidavit, but he didn't actually get the new affidavit until after the decision was rendered, right?
I believe that at an oral argument on May 12th of last year, the court ultimately considered an updated affidavit.
Yes, but was that the argument on the Rule 60B motion?
Well, I think the argument was essentially that the attorney's fees should be updated based upon.
And that was after the decision he had rendered his decision on the case in chief?
Yes, except that I believe that the court may have subsequently modified its decision.
That's fine. I just wanted to make sure I had the timing right.
Yeah, that's right. The court issued a clarifying order on May 17th, which was, I think, 4 days after after that oral argument.
Okay.
Thank
you. Thank you. Red light is blinking. You're 2 minutes over.
Okay. I'd like to please just rely on everything in my brief for the remaining arguments. Thank you.
Yeah, and there's
Yeah,
one more.
I just want to ask one quick question. I know your time is up, but this has been on my mind. When this relationship terminated on December 31st, 2018, when the defendants lost access to that money, how much money after that date was assessed to them for interest on that money that they no longer had access to?
My understanding is that the original email from Maureen Appleyard to Pre-Owned stated that 3 interest payments had been made, beginning, I think, February, March, and April of 2019. So I think that that's the time where the Appleyards essentially declared the note in default.
But do you have a sum? And I'm trying to understand how much money the plaintiffs believe the defendants owed as a result of the interest that was accruing after December 31st, 2018.
So it was, as of April 10th, 2019, the interest payments due for the 3 missed months were in chronological order: $7,131.6, $7,274.23, and $6,698.72. So the first one, at least, is the then outstanding principal balance, which was $356,580 times 1%, times 2, because it was a 12% per annum, ultimately at the default rate, so it was times 2. So the first one, 7131.6, was essentially 2% of $356,580.
Okay, thank you.
Thank you
Thank
both.
you.
All right, our final case of the day is 2022 P0252, Gulrich and another versus Race Street Properties. And Ms. Gulrich, you will go first.
Okay, thank you. Do I go now?
Yes, you go now, and you come up, and let me just say hello so I make sure we're hearing your voice from the microphone.
Hello, Justices at the appeal bench. This is the sign for a greeting.
All right. You can proceed with your argument.
This is an appeal against the dismissal that was issued in a lower court in Franklin County, Massachusetts. On behalf of the family, I am one of we the people. I have a mantle of a 35-year wife and a mom as a homeschooler of kids now in their 30s, successful entrepreneurs. I am first generation, grew up in a parish school with 12 years of Latin. I have a master's plus 30 at my parents' insistence at Ivy Leagues in Boston and Cambridge. I have learned to act and think convexly and concavely, a unique trait in this world, except for judiciary. Mr. Corey issued his decision, 2.5 pages, to an order. I think it was called the decision and order on the motion to dismiss by the opposing counsel. And as far as I know, for this appeal, there are only 3 instruments that have been filed. Our appellant brief and appendix, the appellee's brief and appendix, and our reply brief.
You can be assured that we've read everything that both of you have filed.
That was my next question. Thank you.
You can be assured of that.
Great.
Let me ask you this question. I just want to make sure that we're on the same page about what the problem is here. Judge Carey said, he said, and you think he's wrong, but he said, this case can't be heard in the Superior Court, but you can hear it could be heard in the district court down the road. Do you understand that is the bottom line of his decision, is that the case needed to be refiled in the district court?
Refiled is not the word I understood he said. He said it could be heard, which means someone had to refile it, not me, not the other side, I don't know who. But the bottom line for that is that neither Mr. Carey as the judiciary nor Mr. Farber as the defendant at the time opted to move that, and no one said to me I had to move it. In fact, the law that myself and my husband honor in this matter says that the case may be heard in the Superior Court, but the opposing counsel said it should be heard, or it shall. He changed the word may that's in the law to a different word.
Well, you're right that the sticky issue in this case is what the word may means in that statute. Is it a choice between going to the commissioner or to the district court, or does it mean that you could also go to Superior Court? In order to be in Superior Court, though, you have to have a case that's worth more than $50,000. And your civil action cover sheet said $7,600 or $700. And that's also a separate problem, if you will. And cases under $50,000 are heard in general, not always, but in general, in the district court.
May I answer your concern, ma'am?
Please. And I can't give you legal advice, but I want you to know what's on my mind, and I'm speaking only for myself, in looking at all your papers and wanting to make sure that you understand that there are really separate issues in the case. There's the Superior Court issue, but there's also the amount in controversy.
Okay, my head is swimming a little bit, but I'm going to say to you, please look at the cover sheet that I filed today with the clerk on the first floor. It clearly shows an iceberg where the tip is what I'm coming to you for today. I am coming to you for a 93A complaint about fraud of a licensed warehouser in Massachusetts. The issue is now, because that was not heard, the tip of the iceberg, we've gone past the Titanic. Our things are gone, and I call it theft, because the poor business practices, which is why I brought a 93A in the Superior Court, such as not giving an invoice timely, not ever giving an inventory until pressed, relocating the stuff way outside of the county, in another building, not even the address of the business. There's a whole bunch of poor business practice issues that in my mind lead to a 93A consumer fraud complaint. And now the things are gone and our family has been damaged. In a nutshell, that's how I see what this is about. Should I continue?
Yes, please.
Okay. I'm appealing the decision because Mr. Carey was swayed in his thinking, in my belief, by the opposing counsel in the hearing to deal with the dismissal. And also he was swayed because once he heard a different point of view, or a point of view that he liked, it became a problem that was a resolution, an easy resolution to a problem that he wasn't prepared for. In the transcript that I provided in the brief coming here, I did a line-by-line analysis of the wording that the transcriptionist, the official transcriptionist, had typed. And it's clear that the judge said he wasn't prepared for the motion to dismiss, yet he issued a dismissal. Additionally, as another small point, maybe it's not small to you, but maybe it is, in the docket for Mr. Carey's case, it was interesting to me that we finally got to a trial issue, and the trial issue was scheduled on the docket by a man named Mr. Agostini, a judge, who was the original hearing officer or judiciary for the original foreclosure case. And then it was canceled like that, the same day that Mr. Carey issued his decision. And I think that's a real problem that's maybe systemic in the court system in general. Look at what's happening in the world now. I can go through the themes that I picked out, but I tried to because I'm not technically savvy like a lawyer might be. I did them on my computer and I printed them out with lines for you to take notes, but I don't know that we're going to go through this whole thing like I had anticipated. The decision is wrong.
Your time is yours. You tell us whatever you would like to tell us.
But I like to do it organized, and I'm not able to do that. I'm sorry. The decision is wrong because it relies upon items, in his own words in the decision, items 3 through 8 are avoided completely, and he depends on 1 and 2, which basically tells me that he says, oh, he can't do anything about the foreclosure that happened at the bottom of the iceberg under the water. We're only talking about the tip. And so we never discussed the poor business practices that law caused me to go to a 93A complaint. I also believe that he was in error because 234, MGL, Massachusetts General Law 234, says that a violation of that is a violation of 93A. That's how I got to 93A in the first place. But 93A doesn't have a converse mandated thing. So I think that for Mr. Carey to say that it follows that you dismiss without having decided or even addressed items 3 to 8, which are the poor business practices, is in error. I think the decision is also in error because of the, which I just mentioned, of the almost trial with the judge from the original foreclosure, and then it was canceled in a heartbeat. And that, to me, this page 3 that I put in my filing with you, is the heart and basis and soul of our family. We are inhabitants, we the people live on the soil, and the judiciary is supposed to be an unbiased judgment of fact and law. Well, the facts in this case, 3 through 8, the poor business practices never got heard. Only the law got heard, and the law was, well, I'm going to rely on Mr. Agassini's thing that already happened, and I can't change it, so therefore I'm dismissing. And I don't think that's fair to the people. Our children now wonder about living in America because they see that the judiciary did not protect them like a consumer protection law might do. They see that their childhood, my daughter asks me, what do I do with my childhood? When all her things are gone, because I had 72 hours to get the hell out of the house. And I left very nicely on the day we were advised I was to leave, assuming that we would have lawful storage and shipping of our things and I'd get them back. But it wasn't lawful and it wasn't legal either, and that's what the 93A is about. We have asked for 7 remedies. The same as we're asking for them here today, the same as we asked for them in the beginning. And I want to kind of briefly, I guess, address those. Number 1, we'd like to overturn the Carey dismissal. I can go into a lot of detail on that, but I just want to run through the remedies. We'd like written acknowledgement that the Superior Court in Franklin County does have jurisdiction over 93A, which the opposing party says they do not, that I should go to district court. And we'd like to have someone remand this matter of the poor business practices back to the Franklin County Superior Court so that we can get to the bottom of where is our family estate. We don't know where our things are now. They say they were sold. I went to the auction. My husband went to the auction. We got auction numbers, and we watched the auctioneer, and 3 constables in the room. No Mr. White from Ray Street Properties was present. One gentleman bid for $2,000 for 25 years of a family estate from an 8-bedroom house with a huge barn. And the auctioneer gavelled the hammer and said, no sale. He didn't accept the $2,000 offer. Nobody else offered. There was nothing in the hall, and I brought today, so you can know, I found my pictures getting ready for this, my disc of pictures from that day, and there is, for you to know, next to Mr. Race's official licensed property at 360, whatever street it is there in Holyoke, there is on the sign on the wall, which I have a photo of, that he has next door a shop where he sells goods and personal property. So I'm of the opinion that maybe he fenced our things because we couldn't get to agreement. We went down once to see him. He suggested we take some things out or identify some things, which we gratefully did. We brought our son, took care of the whole thing, so we thought. He said he was giving them away to a needy police officer who fixes bicycles for children or some such thing. We have no idea. Our things were not in the building at 460 Ray Street. They were at least 2 or 3 blocks down, and that was more than 30 miles from the home in Millers Falls, when in truth there are other warehouse people in Franklin County. Now, the opposing counsel will tell you also that we didn't serve right, or we should have used the Hampden County Sheriff. I don't think that's necessarily true because somewhere in the law, and I'm not prepared for it to quote it to you folks today, we can use USPS certified.
You can use USPS certified. I believe the rule says if the person is out of state, if the entity is out of state.
You could be right. I don't really remember that little detail. I'm sorry.
Yeah, no, I understand. It's hard when you're pro se, but
we're,
it's just something to keep in the back of your mind, depending on, just something to keep in the back of your mind for the future.
question that it raises what the opposing counsel is bringing. Did they not get the notice? That's not true at all, because apparently Mr. White did contact me and say, come and get rid of this collection in this corner. I have a deal. And he did give me one item because, I guess by law, one item I'm allowed to get in a foreclosure or eviction. But this is not about a foreclosure or eviction. This is about poor business practices of a warehouseman, and that's what's not being addressed.
We understand that. We understand that this is different than the foreclosure. If I may ask you a question.
Yes.
Do you object to having this case heard in the district court?
That's a broad question in my mind.
Mm-hmm.
Because I would not object it, I guess. I would not have objected to the Superior Court one, but when I see that an original judge is scheduled for trial and then canceled, I wonder what's going to happen in district court. I don't know.
If Judge Carey had dismissed the case for lack of jurisdiction in the Superior Court, it would not be surprising to see the trial canceled. I appreciate that you may see other things in that, but there is an alternative narrative. I was just wondering if you had some kind of fundamental fairness objection to being heard in the district court, and if so, I wanted to give you the opportunity to state it.
Well, I guess I'm going to go back to a fundamental fairness objective. This four-block diagram explains, I hope, to you folks visually, because I didn't bring a computer and stuff, that rights are not privileges, and
Right.
we the people have inherent rights, and the judiciary and the legislative and executive have privileges to go by. So I don't know if it's an uphill battle in any court I go to because of that difference. I don't know how to answer your question, ma'am.
Okay.
I'm sorry.
I just wanted to give you the chance to talk about it. Is there anything else that you would like to say?
I'd like to pay attention to the Latin on the bottom, because to me, by the 12th grade, we were speaking full Latin in class and in church and everywhere else. It was not allowed to speak English. At home, I heard English primarily, and French and Gaelic. So language to me is an impression of what's in the invisible mind, whatever language it is. And it's pretty hard for me to agree to something that I don't know. Like a contract is supposed to let you know transparently, you know, buyer and seller, or giver and taker, or whatever it is, and all the caveats are supposed to be in there. But that's not true in the judiciary system, because to my mind, I come in here naked as a jaybird, if you will, as a mom and a wife, but I have to face all the books behind you, you folks who have lots of knowledge, an opposing counsel perhaps who has a license, and a license is something in my book, in my world, that gives permission to do something which would be otherwise unlawful.
Well, thank you very much for your argument. The red light means that your time is up. We gave you a little extra time.
Thank you, ma'am.
All
So I
righty.
just need a minute to collect myself.
No,
and-
well, you'll just sit down, and now the other side will have its chance to make its argument, and you can just sit and listen.
And can I have a drink of water while I do
Yes,
that?
you can have a drink of
Thank
water. We don't do any rebuttal, so you just sit and listen, and then when you're both done, we'll conclude the hearing for today.
Thank you.
Okay.
Good morning. I believe it still is, Your Honors. Lawrence Farber on behalf of Ray Street Properties, LLC. I'm going to try to make this brief, Your Honors. I think the appellant, unfortunately being not an attorney, does not seem to quite appreciate the difference between procedural arguments and substantive arguments here. And I can understand that that's a difficulty, but we here at the courts have to follow the procedures as the legislature and as the SJC has given it to us. Here, the key on this is there's 3 violations that were committed in procedural. One is filing in the wrong court based on subject matter jurisdiction under 239, Section 4H. As Your Honor has, Justice Sullivan, you have specifically pointed out, the real question is the turning on the word may, and I think it is clear from the reading of that statute that the may refers to that you can either go to the commission and have it heard there for up to $5,000, or you may bring it in the court which brought the summary process.
Well, why is it so clear when they say there's a 93A violation? And we all know that the Superior Court has jurisdiction over 93A violations.
93A does not necessarily, Your Honor, mean that every court has the right to hear that 93A. Housing court, for example, has the right to 93A also, but they can't hear a car case involving the purchase of a car.
But the Superior Court, unless there's a case or a statute that you can point us to, the Superior Court does have jurisdiction over all 93A cases, right?
That is correct, Your Honor, except for when a statute specifically says this kind of case has to be brought in the court that heard the summary process. If the Superior Court had heard the summary process, then it would have. It didn't hear.
Well, that's where the may comes in, right? And what does that may refer to?
It is clear from the reading of the statute, I believe, that the may refers to here as the alternative to going to the commissioner. You can either go to the commissioner or you can go to the court that heard the summary process. It does not say, and I think it would have said, to any court of competent jurisdiction for 93A or for anything else. It doesn't. It specifically limits it to the summary process court that heard that case.
Right.
And the reason for that,
But
Your
does
Honor,
that mean it's jurisdictional, or does that mean it's a choice of forum? I mean, part of the disturbing aspect of this is that it came up on a jurisdictional argument, and so it was dismissed rather than transferred.
I believe that it is jurisdictional. Now, could have she filed in the district court? And I think, again, not being an attorney, the appellants don't realize that the burden is on them to do that, not on us. Our burden is to get the case dismissed if we believe it was wrongfully brought in that court, and then it is up to the plaintiff to move the case to the proper court.
Could the Superior Court have transferred the case to the district court?
Not if it believed there was subject matter jurisdiction, which we agree with. It would have if it was a venue only.
But how can it be subject matter jurisdiction if Chapter 93A cases can be heard in the Superior Court? That's what's troubling me about your argument.
I understand, Your Honor.
I appreciate the choice of forum argument that you're making, but to elevate it to jurisdiction, you may be right. Under the one trial rules, maybe you're right. I don't know. But as a practical matter, do you really perceive an impediment to having the Superior Court transfer the case?
I don't see them having a difficulty in transferring a case, but in this specific instance, the statute only gives jurisdiction to the court that heard the summary process. Therefore, that becomes a subject matter jurisdiction. Although they'd normally be able to hear other types of 93A, and there's no question that Superior Court does have that right, because the statute limits the jurisdiction, that becomes a subject matter jurisdiction. It says no other case.
The dismissal is without prejudice, right?
What?
The dismissal is without prejudice, right?
That is correct. We don't argue that it could have been brought in the district court after the dismissal. There is the second problem, which I believe is not just a venue problem, which is the service of process, which Your Honor has correctly pointed out. There is no...
That would also be without prejudice, right?
That would be without prejudice.
And all of these grounds would be without prejudice, right?
That is correct. At this point, since the 120 days has gone by for service, it cannot be resurrected at this point. It would have to be a new case.
Did your client appear and oppose the TRO?
We did, Your Honor, and I'll be honest with you.
Does that waive service?
First, if it's subject matter jurisdiction, never can be. To be
No, no, no.
quite,
Does that waive service?
No, I don't believe so, Your Honor. The issue on that was...
What's your best case for that?
Yeah. The reason, Your Honor, is we were addressing only the TRO. And the issue in that was the actual sale was just a day or two away. And to be quite honest, I didn't even look at everything at that time. I didn't have the time. We were there to address only the TRO. I don't believe it waives the service then for the remaining parts of the case. It only was for the TRO.
There was also a limited response to discovery, was there not?
I don't even believe we did
Was there
discovery.
answers to interrogatories?
What?
Were there answers to interrogatories?
I can't remember, Your Honor.
Okay.
I'll be quite honest.
Okay. It's not a question we're likely to be able to resolve ourselves regardless. And then the third issue, of course, is the jurisdictional amount.
That, Your Honor, there's no question is a venue and the court could have, by its sua sponte itself, removed down to the district court. I believe when it was combined with the other two issues, they felt they didn't have the right to do it in this instance. So that I don't believe that ever really got to. I don't think it would have ever been able to be heard in the Superior Court, not based on subject matter jurisdiction, but an improper venue, but they could have transferred it to the proper venue if that was the only issue before it. But I don't believe, based on the fact that there was the two other improper problems that the court had to hear, they felt the dismissal based on subject matter jurisdiction made more sense, and then we also have, of course, the service problem.
What is your best case for the proposition that the language may in Section 4H creates a jurisdictional bar?
The best argument, Your Honor, is they would have said otherwise. In other words, they could have, as I've already said in any competent court of any jurisdiction. They didn't. They limited, because they limited to only one court that could hear it, i.e. the summary process court, whatever that is, I believe that makes it subject matter jurisdiction to all other courts because they don't have the right to hear that, period.
That amendment went in roughly 2004, right?
I don't know the year of the amendment, Your Honor.
Right. There's very little legislative history on it. But the amendment became operative before a number of the SJC cases that confirmed the somewhat expansive jurisdiction of the district court and the housing court with respect to housing matters.
I believe it did occur after the single trial.
Is it possible that that language was meant to simply give direction that the district court could hear this and the 93A?
I think, Your Honor,
because it's not strictly.
Sorry.
This is not strictly what would fall within the jurisdiction of the housing court or the district court acting as the housing court. It's a step removed because it's just a warehouseman's case.
Yes and no, Your Honor. The problem with that is we have to look at the express language of the statute. We can't interpret a statute when it is plain on its face in any way other than what makes sense to that statute the way it is written. That, I believe, in this case, makes it very clear they said only this. And the reasoning, Your Honor, is clearly that the warehouser is ancillary to any eviction case. They are not the moving party for it. They are hired.
They're not even a party to the eviction case, which is why the legislature may have seen fit to say, oh, and by the way, the same court that heard the eviction case may also hear this. Whether that was intended to be exclusive and jurisdictional is the very hard question that you have posed.
And I think, Your Honor, again, we have to look at the exact language of the statute, which doesn't make it a question as to whether it could go anywhere else. It says it has to be brought in the summary process court that heard the case. I don't know if you have any other questions. I could address some of the substance on this, but I don't believe that's the case. The sale of the auction, that actually was proper because my clients had a lien. That's what stimulates it.
Well, That is the merits, and as
Right,
I
that's
think
the
we
reason why I'm
all
not
agree,
really addressing them.
the merits have never been addressed in this case. We're on a strictly procedural issue, and the question is whether or not, if the case were refiled tomorrow in the district court, is there any bar to the refiling in the district court?
Only if the statute of limitations in some way was triggered, and the question would be, is it a 3 or 4 year statute of limitations? Because it's 93A, it may be 4 years, but if it's a straight tort, then it's not.
Well, and does the pendency of the case in the Superior Court toll the running of the statute?
I don't believe so, Your Honor. There is nothing, I have litigated that issue in the past, and no, it does not toll anything.
Okay.
I'll waive the rest of my time unless the court has any questions.
And any questions? Okay. Thank you both very much. You've both done a very good job. There's no rebuttal.
What happens from here now procedurally? I just heard, I guess I goofed procedurally. What happens here?
We will issue a decision and you will get it.
Thank you, Your Honor.
That concludes our sitting for today. We would like to thank everybody who participated in this session, the parties. We thank our court officers, the members of the clerk's office, our law clerks and interns. We stand in recess. Thank you very much.